Yes.
My Lords, I appear together with Ms Brander for the appellants. The respondents today are represented by Mr Grzinski and Mr Summers, and the Home Secretary by Mr Jaffe.
You've given us some pretty exhaustive reading material, and obviously we're familiar with the facts. What is in this litigation, in the end, it's a point of principle which is being fought with a view to recovery of damages?
Yes, ultimately with a view to recovery of damages, but we now face, in light of the Court of Appeal's judgment, a very important point of principle, which is whether or not the domestic courts are going to depart from what in our submission is the clear, constant and very long-standing jurisprudence of the European Court.
Well, we understand that point, but if it's not within C, the Court of Appeal held out the prospect that it was within B, but didn't feel that it had sufficient material before it to investigate that. So if you succeeded on C, the matter would have to go back for a retrial on the facts under B, wouldn't it?
Well, first, the court would have to establish whether or not the respondents are correct in their characterisation of Article 5.1b, because if the Supreme Court were to hold they are correct, then there wouldn't be any need for a trial on the facts, because if their characterisation is correct, there would be no need for a warning to have been given.
I see, yes, quite.
And therefore that issue does fall to be resolved here.
Yes.
What we would then submit is that in relation to our characterisation, if we are correct, we would submit that this court is, albeit the Court of Appeal declined to do so, is capable of making a determination on the evidence before it as to whether or not any warning ever was given in the event that the court holds that 5.1b requires a warning to have been given.
Yes, right. Well, we may have to hear submissions on that particular point as well. All right, well, we'd better get on. And the only other point I'd make is that you've got a day and a half, but as I say, you've given us very substantial material, and you needn't feel you have to use the whole day and a half, because we were slightly surprised that it was listed for as long as that.
Well, I'm quite certain that the court will interrupt me and tell me to rush and move on if I am going over material that the court is very familiar with. Because the question here is one of what is the Strasbourg jurisprudence?
Well, the difficulty with the Strasbourg jurisprudence, as we all know from many cases, is that you can often find different little pointers or strands in different authorities, and to read them like common law authorities is not necessarily helpful or the right way. You have to take a slightly broader and more holistic view. But that said, if we interrupt you anymore, we'll probably slow down the progress rather than...
Well, I should indicate before I start, because it seems that there may well be a good degree of interruption in light of what your Lordship has said. But our submission is that while that is true about a lot of Strasbourg authority, in this particular instance, the case law is clear, consistent. There is a long line, and it involves and includes many Grand Chamber decisions. And there are simply two decisions which both the Court of Appeal and the respondents are able to point to, which in our submission do not constitute another strand in any sense. And in order for us to make that point, my lords, I'm afraid I am going to have to take your lordships to critical parts of a number of cases. So again, I apologise.
Well, bear in mind that they're all, insofar as they're in your case, you don't need to do so quite as exhaustively as you would otherwise.
I bear that in mind. Can we start by looking at the language used in Article 5.1 itself?
A good place to start.
And then we'll look at what the authorities say about it. Because in our submission, the language of Article 5.1 points, or sorry, Article 5, not Article 5.1, points very, very clearly to the reading of Article 5.1c that the court in Ostendorf settled upon. And the first provision to focus on is Article 5.1a. So the opening lines, everybody has the right to liberty and security of the person. No one shall be deprived of his liberty save in the following cases and in accordance with the procedure prescribed by law. So Article 5.1, the very opening words, make it clear that the circumstances in which detention is permissible under Article 5 are exhaustively set out in what follows.
Well, we now know that's actually not quite correct because of the case of Hassan in the United Kingdom. There are glosses.
We'll come to Hassan,
Yes, right.
and we'll come to see the circumstances in which those glosses arose. And in
Do
my
we know anything about the background to Article 5, in the sense that since there was large input from UK lawyers,
there was a
it
large
would have been rather odd if they'd intended to exclude arrest for breach of peace.
Well, they haven't excluded arrest for breach of the peace. Arrest for breach of the peace falls squarely within Article 5.1c, as long as the purpose of the arrest is to bring the person before a magistrate's court for a bindover, albeit that purpose may be conditional. But what it
But I mean,
requires...
before, at the time this was all drafted, the sort of thing that happened in this case, I suspect, would have been regarded as perfectly lawful and would have been accepted as such by those advising on the drafting of Article 5.
In my submission, I'm not confident that would have been the case, because the case law on the breach of the peace has always been that there is a power to arrest, but the power to arrest is coupled with the requirement to bring a person before a magistrate's court in order that the magistrates can consider a bindover. Breach of the peace is an offence in Strasbourg law, but it is an activity on the part of an individual which allows those seeking to prevent it to take all manner of preventative measures short of arrest. Arrest is one option. Where arrest is the option that is taken, it must be coupled with an intention to bring the person before the court for the purposes of binding them over. But we'll come to that.
Is that advanced as a proposition of common law or convention law?
As a proposition of common law.
Right, so you're going to make good that.
So we'll make that good when we come to the Williamson case.
So you say you can't arrest for breach of the peace or threatened breach of the peace unless there is an intention to seek a bindover order from the court.
Yes, which can be a conditional intention. So at the time that you exercise your powers of arrest, you have it in mind that should, following investigation, see Brogan, it be such that the circumstances in which a bindover would be appropriate exist, then you will bring the person before the magistrate's court.
Therefore, if it is not contemplated that the need for a bindover will exist, because this is seen to be a one-off situation of brief duration, there is no power.
There is no power.
At common law.
At common law.
So why are we arguing about the convention?
Because our submission is that the common law and the convention are entirely together and they
Yes,
run in
of
tandem
course.
here.
But you'll deal with the facts. But if there was no intention to seek a bindover, then you succeed at common law.
Yeah, that is
irrespective of the convention.
That is true. And so the case could have been formulated in that way. It wasn't.
Well, so why are we arguing? What's the argument about the convention?
Well, because the case was run on the basis that the detention was unlawful as a matter of convention law, and it fell outside of Article 5.
It's all very odd.
Yes, and then there is also the argument that even if we are wrong about the common law, we also have the convention.
Ah, I see. Well, if there's an argument that you may be wrong about the common law, I can understand the convention point.
And we do, and then our answer would be...
Let us just ask.
My only frown is because the divisional court found that the arrest was lawful at common law. Permission to appeal was refused on that issue. And there isn't an issue before this court, so far as I understood until just now, that this arrest is unlawful at common law.
On what basis, just remind us, did the divisional court find it was lawful at common law?
Because they found that the requirements of the common law, namely that there was an imminent breach of the peace constituted by the threat of violence, was met on the facts of the case.
Yes, but did they deal with the point which Mr. Kaufman's just made, that at common law it's also necessary to have an intention to seek a bind-over for the future?
Well, my lord, we wouldn't accept that is what the common law requires.
Right.
What the common law requires, as set out by my Lord Dyson and Williamson, is rather different. I don't want to interrupt
right.
my
Well,
friend,
I see the
but
beginning.
The common law issue is no, as far as I understood, not before this court.
No. Thank you.
But our position would be, and is, that the convention, whatever the common law position is, the convention accommodates it, either under Article 5.1c, where there is an intention to seek a bind-over, or under Article 5.1b, where there is no such intention to seek a bind-over.
So if, for example, the police accompany a woman to a house occupied by a man where there's a history of a violent domestic relationship, and there's every risk that unless the police control it, there will be violence. And if they hold the man in one room while they help the woman to remove hers and the child's belongings, and if they do that in circumstances where they see this is a one-off, so there's no conceived need for a bind-over in the future, and they fully anticipate that the whole operation will be done in half an hour, they have actually got no power to arrest him for that half hour.
So there are a number of answers to that. They do have a power to arrest. So, for example, they could say to him, now you are to remain in this room now for the next half an hour whilst we remove all the belongings of your wife and her child. If the individual refuses to, they have a power of arrest. That's the 5.1b route, perfectly capable of accommodating that situation. The second answer is that in that particular hypothetical example, it's quite unlikely.
Where would the power of arrest arise at common law? That's 5.1b, but we're talking about common law, where if the common law is such that if there is no perception of a need for a bind-over because it's seen as a one-off situation and the anticipated duration is very short, then you say there is no power of arrest at common law. It would seem to follow that on the everyday example I've given to you, forget about Article 5, it would be unlawful at common law.
Well, the answer to that is it wouldn't be an arrest. That would be a detention which doesn't amount to an arrest. They're not being taken to the police station. They are being told, say, in the same circumstances as, say, the police come along and say to somebody, you need to be searched. You stand still whilst we're searching you.
Right.
So
you can detain for breach of the peace, for threatened breach of the peace, without an intention to seek a bind-over.
Exactly.
Right.
There is a distinction between an arrest and taking somebody and removing them to a police station and the other measures that are available to the police short of arrest. So the prime example of a measure available to the police short of arrest is the power to kettle. Now, the power to kettle is a power to contain individuals within a confined space for up to 7 hours or more. The limit hasn't been specified, but we know from the Austin case
Yes.
that 7 hours or more of containment in circumstances where you have no access to toilet facilities, food or drink does not amount to a deprivation of liberty. And the police are entitled to do that as a measure short of arrest to prevent an immediate threat of a breach of the peace. And they're entitled in those circumstances to detain individuals who do not themselves pose any threat, entirely innocent individuals. So the law and the convention already accommodates a very, very important measure of crowd control to restore public order where we are contemplating a threatened breach of the peace and an immediate threat to the breach of the peace. So it is very, very important moving forward to distinguish between a detention that is neither an arrest nor a deprivation of liberty and an arrest. And in this case, because the claimants were arrested, placed in police vans and taken to police stations, it was not open to the police to argue that they had not been deprived of their liberty for Article 5 purposes, which is why we are confronted by what Strasbourg case law has consistently said are the limits of permissible detention under Articles 5, 1A to F. So can we go back now and look at Article 5 to see what on a pure reading of its terms it indicates 5.1c to cover. So we've started with 5.1, it's an exhaustive list, then 5.1a, the lawful detention of a person after conviction by a competent court. So now there is no doubt that Article 5.1a is concerned with detention following criminal conviction, following trial. So that would cover anybody who is remanded post-trial, anybody who is sentenced post-trial. B, the lawful arrest or detention of a person for non-compliance with the lawful order of a court or in order to secure the fulfilment of any obligation prescribed by law. So note the word arrest or detention there, because we can see that it appears in some of these provisions and not in others. C, the lawful arrest or detention of a person effected for the purpose of bringing him before the competent legal authority, condition 1, and then on reasonable suspicion of having committed an offence, or when it's reasonably considered necessary to prevent his committing an offence or fleeing after having done so. So again, we're concerned with a deprivation of liberty by arrest or detention for a specific purpose, namely to bring them before a competent court, on 3 separate bases justifying the detention. D, the detention of a minor by lawful order for the purposes of education or supervision, or his lawful detention for the purposes of bringing him before a competent legal authority. E, the lawful detention of persons for the prevention of the spreading of infectious diseases or persons of unsound mind, alcoholics, drug addicts or vagrants. F, the lawful arrest or detention of a person to prevent his effecting an unauthorised entry into a country or of a person against whom action is being taken with a view to deportation or extradition. So some provisions concern arrest and detention, some concern only arrest. Article 5.1c, we can see all the grounds, the bases upon which somebody can be detained for the purposes of bringing them before a court are concerned with the commission of criminal offences. So there's a strong indication there that 5.1c has something to do with criminal offending. If we then turn to 5.2, everyone who is arrested shall be informed promptly, in a language which he understands, of the reasons for his arrest and of any charge against him. So arrest is clearly concerned with an arrest in relation to the commission of a criminal offence. And if we go back to B, C, and F, we can see that these are all bases of a detention which may involve criminality. For example, failure to comply with a court order, or unlawfully making entry into a country, can all be met with criminal culpability and sanctions. Then we have 5.3. 5.3, which is linked to 5.1c by its language. Everyone arrested or detained in accordance with the provisions of paragraph 1c of this article shall be brought promptly before a judge or other officer authorised to exercise judicial power, and shall be entitled to trial within a reasonable time or to release pending trial. Release may be on conditions by guarantees to appear for trial. May be conditional, I'm sorry. So you have to come, if you're arrested or detained under 5.1c, for the purpose of bringing you before the court, you have to then be brought before the court promptly. And when you're brought before the court, you either have to be tried or something else has to happen if you're not tried. There are 2 elements there. So the court that you're brought before has to do something.
Well, you have to be tried, don't you? If you read it literally, you have to be tried within a reasonable time or released pending trial.
Yes.
How does that fit with the fact that detention doesn't appear to necessarily to relate to any charge being brought? Was paragraph 2 makes it clear that it's only arrest which relates to situations where there may be a charge.
The purpose of detention is to bring you before a court for trial.
Why? Because 2 is dealing with arrest when you're going to be tried, and that suggests that detention is not dealing with situations where you'll necessarily be tried.
No, detention is within Article 5.1c something which can take place on one of the 3 grounds identified, be that arrest or be it detention. So if one looks at the start of a criminal process will start either with an arrest or with a summons, for example, in this country. An individual could be summoned to the court and detained as a consequence of being summoned. So you can have detention taking place in the course of a criminal process that is not simply detention following arrest. And as we'll see, Article 5.1c is concerned with all forms of detention, whether they be as a result of arrest or in the course of the criminal process, but all forms of detention that take place pre-trial.
But if you just look at C alone, I mean, I take your point about 5.3, but if you just look at C alone, why do you say that the second of the 3 grounds contemplates that there be criminal proceedings in process or in prospect?
The second on its own doesn't. One has to look at 5.1c in context, and one has to look at it, therefore, together with the wording of 5.1c, which conditions the ground of detention, the second ground of detention.
Now, you accept that 5.1c alone, that second ground doesn't tell you that what is in prospect is criminal proceedings?
No, in my submission, it does, in that the detention must be effected for the purpose of bringing him before the competent legal authority. So that is an anterior and separate
But that doesn't
purpose.
necessarily mean that it's a legal authority which is going to be dealing with criminal proceedings.
No.
It could be a legal authority to adjudicate upon whether or not the detention should continue.
But also, if the purpose is to stop him committing the crime, then it seems pretty odd to say that it's contemplating being prosecuted for it. The whole purpose is to stop him.
No, the purpose is to bring the individual before a competent court.
No, under
the
the
ground of detention.
Second heading is when it's considered necessary to prevent him committing an offence.
I understand.
Now, if that purpose is achieved, he won't have committed an offence.
Yes.
So why bring him before
Because the purpose of detention, to bring the individual before a court, is not identical to the grounds upon which somebody may be detained for the purpose of bringing them before the court. So if you arrest somebody in relation to a suspected criminal offence and you intend to set criminal proceedings in train, there may be a number of bases upon which you can detain that individual pending trial. The 3 bases in Article 5.1c are concerned with the grounds upon which somebody may be detained for the separate purpose of bringing them before a competent court. Now, 5.1c has to be read together with 5.3, which is what makes it clear what the purpose of bringing them before the competent court is, and that is in order that they might be tried. It's not that they might be tried...
Sorry, how does that work? I mean, if the second ground is it's necessary to prevent, as my Lord says, to prevent, so what's contemplated here is that the detention will prevent an offence.
Yes.
So how,
As it did
what trial will then, what trial can be within the contemplation of Article 5.3?
That's precisely the point. The trial that is in the contemplation, because if we look at this on the basis that all one needs to do to fall within 5.1c is to intend to prevent the commission of an offence, and thereafter to bring the person before a competent court to determine the legality of the detention on the basis of preventing that criminal offence, the question then arises, if one looks at Article 5.3, what is the trial within a reasonable time that the person who is so detained is entitled to?
So I don't think before you do that, I'm very interested to know your answer to Lord Dyson's question. I don't think we've had it. He said, if the purpose is to prevent the commission of an offence, and that purpose succeeds, what trial is thereafter in contemplation?
Yes, my answer is the trial that is in contemplation is a trial of a criminal offence.
And what is the criminal offence if the purpose of preventing a criminal offence has been successful?
it will be a criminal offence that one has reasonable grounds to suspect the individual has been committed.
But you haven't. But on the
You prevented it. And I thought earlier you were saying it was some further future hypothetical criminal offence in respect of which the person might be bound over. But by definition, there may be situations where there is no likelihood of any such future offence.
The purpose having been successful in preventing, there is nevertheless a contemplation of a trial. Trial for what?
And that is precisely why one cannot read this provision as permitting you simply to detain somebody for the purpose of preventing a criminal offence.
But what's the answer to the question? Trial for what?
If I can explain. So what it contemplates is you cannot arrest anybody for purely preventative purposes. This 51C governs arrest in the course of criminal proceedings. So if there are, as a matter of domestic law, grounds upon which you can arrest somebody and set criminal proceedings in motion, then what 51C says is you can detain them for that purpose, the purpose of setting criminal proceedings in motion, but only on one of the three grounds that are identified. So it may be that you want to detain them and are entitled to detain them on the basis alone of reasonable grounds to suspect. But in fact, reasonable grounds to suspect, if it's a very minor offence, may not be sufficient to justify their detention. So it may be that you can nonetheless still detain them in order to prevent them fleeing if you have reason to believe and evidence that they will try to flee before trial. So there is no basis under Article 51C upon which you can simply try somebody on the question of whether or not their preventative detention is lawful. It doesn't contemplate that. It contemplates that criminal proceedings are being set in motion, and if and insofar as that is lawful, C5.1, it has to be lawful, insofar as your domestic law allows you to institute criminal proceedings, because domestic legal orders may provide for different bases upon which you can set criminal proceedings in motion. In some instances, it may be strict liability. It may not be that there is reasonable grounds to suspect. But where, under domestic law, you are entitled to set the criminal process in motion, that is, your purpose is
But it's all pretty odd, isn't it? I mean, I think we understand your submission, but it amounts to this, that if you have a situation where somebody is about to commit an offence, you can only arrest them under 5.1c if you believe that having, by the arrest or detention, prevented them committing that offence, they are nonetheless in the future likely to commit some further undefined offence. In that case, I think you've accepted you could arrest them because you would intend to bind them over in respect of the future offence. It's pretty odd that you can operate preventatively only in that situation and not simply preventatively when the basic object is to prevent the commission of the currently threatened offence.
My lord, it isn't odd at all in that preventative detention, say for example, preventative detention that operates in this country, the IPP, that is something which under Strasbourg law could never operate unless somebody had been convicted first of a criminal offence. You cannot preventatively detain an individual, see Van Drugenbroek onwards, you cannot preventatively detain somebody simply because they present a risk of future offending. That is absolutely out with Article 5. It is also out with the traditions of this country's constitution. We do not preventatively detain people.
But I think you accept that you can preventatively detain people on account of a risk of future offending. But I think, am I not right that you said at the outset you could do so because you could bring them before a magistrate and ask that they be bound over, and that would constitute, apparently, I think you accept, a finding of a criminal offence and a sufficient disposal of a criminal offence. The premise that you can't preventatively detain on account of a risk of future offending seems to be wrong.
On its own. You have to couple it with criminality. Once you've established criminality, that is what the bind-over process does.
So you have to, only in a dual situation where you have...
That's exactly what the discretionary life sentence does. It's exactly what the IPP does. Once criminality has been established in respect of an individual, then the law allows a measure of preventative detention, as long as it was then judicially reviewed under Article 5.4 and determined in the first instance by a court. It allows that, but it does not allow it. I'm sorry, my lord.
No. And all I was going to say is that in case you want to have a further go at it, I confess that I have not understood so far your answer to what I think is a fairly simple question that's been put 3 times. You've answered none of the things. If there's been an answer to it, then the failure to understand it is mine. But the question posed was, if the purpose of the arrest or detention is to prevent a crime, which is foreseen as a one-off situation, and that succeeds, it is averted, what is the trial then in contemplation? Trial for what? Now, we've put that several times, and I won't put it again, but I just should say out of candour that I have not understood an answer to that question.
So can I take you back to the wording of Article 5?
Yeah.
If we could just look at that. So the lawful arrest and detention of a person effective for the purpose of bringing him before the competent legal authority. Now, your question to me is, if the purpose is simply to prevent that person from committing an offence, simply to prevent it, then what is the trial that then has to be?
It is, if you divide them up into 1, 2, 3, A, B, and C.
Yes. My answer,
If you're under 3B, that is to prevent the committing an offence, which is perceived as a one-off risk, and that the avoidance is successful. My question is, what then remains to be tried?
and my answer, my lord, is nothing remains to be tried, which is precisely why Article 5.1c does not operate in this way, because Article 5.1c operates together with Article 5.3 and requires that the purpose of the detention is to bring somebody before a court, that's 5.1c, for what? To be tried within a reasonable time, that's 5.3. So there has to be, when one's looking at purpose in 5.1c, the purpose is an anterior purpose. It is a separate purpose from the basis upon which you can detain somebody in respect of that purpose. So...
But the purpose can include, I just want to get it absolutely straight, I'm reading from what you said originally and I wrote it down, an intention to seek a bind over from the court because that's a common law offence. That counts as a common law offence and an offence in Strasbourg law.
So if we're looking at a breach of the peace in relation to 5.1c and 5.1c operating on the basis which we submitted operates, then if one is arresting somebody with the purpose of bringing them, albeit conditional purpose, before a court to seek a bind over, then one is in the realm of criminal proceedings.
Within 5.1c.
Within 5.1c. So as long as you have that purpose in mind, and then the trial that will take place is not the trial of whether or not their detention is lawful, it is the trial of whether they committed a breach of the peace and whether or not there should be a disposal in the form of a bind over.
I should just raise with you, I've got in front of me Van Dijk and Van Hoof's textbook, which I suppose is probably the most respected textbook on the subject. And page 471 takes the opposite view from the one that you're urging upon us, and cites in support the Trevor Paratoire, which pointed out that it might be necessary to arrest an individual to prevent his committing a crime, even if the facts which showed the intention to commit the crime did not of themselves constitute a criminal offence. So, in other words, the Trevor Paratoire indicate that these words in 5.1c were meant to cover the situation where a person might not yet have committed a crime and therefore couldn't be tried, but nevertheless was reasonably suspected of an intention to commit a crime. And that was what would justify his detention.
And what we find is, this argument has been put around by many commentators for a long time, but what we find in the constant Strasbourg case law from Lawless onwards is a very, very clear line that it is not permissible to detain in that situation, that Article 5.1c is concerned with detention in respect of criminal proceedings, pre-trial, that is pre-charge, post-charge, pre-trial, the whole spectrum, but that the purpose, the overarching purpose for which detention takes place must be to bring the person to trial if that turns out to be evidentially appropriate.
So there must have been a criminal offence already committed.
So,
Do we have that? No. Maybe,
So,
maybe we should get this copied.
Yes.
Yeah.
yes.
Right. Well,
So if we then finally look at 5.3 and 5.4 together. So
Can we get that copy of it?
I think that's on the page.
can we have it copied? Ask one of the JAs to get it copied. Ask one of the judicial assistants whether they could copy the pages.
Okay.
So the purpose of detention must be to bring the person before the competent court. 5.3 requires that they are brought before a court promptly, and they either are released without charge, released pending trial, or entitled to a trial within a reasonable time. So there has to be a trial of something. Now, if they come...
Sorry, we'll get that, but you didn't seem to be surprised by that reference. Do I take it that the Trevor Borough trial have been considered by the European Court of Human Rights, and they've decided to take a different line? Is that what?
The Travo have been considered, I'm
I
sure.
mean, don't worry now, but
Yes, in Lawless they were considered, exactly.
Okay.
Yeah, they have.
right.
And we'll see that the court looked at the different language deployed in the French text.
Well, we
English
can come
text
to
and
that in
so
due course.
So,
Well, what they were concerned about in Lawless was the possibility of indefinite detention without any judicial warrant. Now, that's not a possibility under English law.
yes, that was the immediate issue that arose in Lawless. But Lawless is the start of a train that then led to the contemplation or the clear understanding by the court of Article 5.1c as being concerned with criminal proceedings. And we'll come on and we'll look at Lawless in a moment, but I accept that they don't in Lawless anywhere say it's concerned only with criminal proceedings. They do talk about a trial and entitlement to a trial and within a reasonable time. They don't specify what that trial is in the nature of. But if we look at 5.3 together with 5.4, the individual must be brought promptly before the court, either to be tried. Let's assume the individual is not tried at that point in time. What will then happen to the individual? Well, 5.4 requires that the lawfulness of their detention must be determined speedily by a court. So at that stage of being brought before the court can then consider the legality of the detention for preventative purposes or in order to stop the person fleeing or in order or simply on the ground that they are reasonably suspected to have committed a criminal offence and decide whether or not their detention is lawful.
Yes.
But they are still then separately entitled to a trial within a reasonable time.
Well, that's
Now,
the question, isn't it? I mean, whether paragraph 3 applies to all aspects of Article 5.1c.
and that was settled in the Lawless case, and there's no appeal against that at all.
When you say settled in the Lawless case, I thought that was part of the issue before us.
No, the issue before us, it's accepted, it is accepted, it was accepted by the Court of Appeal, and it is accepted by the respondent that the requirement, the purpose of bringing an individual before the court and the requirement of Article 5.3 that they be tried within a reasonable time applies to all three grounds of detention.
No, I thought what was accepted was that there was a requirement to bring before a competent legal authority in respect of all three. But, I mean, there wouldn't be an issue if they'd accepted that you had to have a trial, as I understand it.
Oh, well, I'm sorry, I have totally misread, because it did not appear to me that they were challenging Lawless, which said in terms that 5.1c and 5.3
was
must be
that
read
you
together.
could read 51C completely disjunctively and disrelate the bringing before a competent legal authority from the latter concepts of prevention of committing an offence. And that's gone. But the question otherwise remains why you have to bring it before a competent legal authority. Whether trial is necessary is an issue.
I'm sorry, I need a little bit of help and clarification here so that I understand the other side's case. My understanding was that they did not take issue with Lawless, insofar as Lawless says in terms 5.1c and 5.3 must be read together.
Well, does it matter whether they did or didn't? I mean, we've got to grapple ourselves with what the provisions mean.
I understand, and I'd just like to clarify what I have to grapple with, because if 5.1c and 5.3 are to be read together, which is what the court said in Lawless, and I haven't seen any challenge to that, then 5.3 requires that when the individual is detained for the purposes of bringing them before the competent court, they are then entitled to a trial within a reasonable time. And Lawless says that the two provisions must be read together. Well, if that is how 5.1c and 5.3 fall to be read by the long-established jurisprudence, then the question does arise of a trial of what?
Well, no, there is another possibility, which is the person has been released, and therefore they've ceased to be detained, and therefore 5.1.3 ceases to have any bite.
Well, that's as a matter of fact,
Yes.
but in order to make sense of this provision, it has to be the case that there is something they can be tried for at the time they are arrested.
Well, that's now we come full circle, which like the bunnies running around the outside of the plate. Because if at the time of the arrest they haven't committed an offence, and the purpose of the arrest is to prevent them from committing an offence, and they are then released, there is, as you say, nothing to be tried.
But one has to read this as a provision which makes sense of the circumstances of any detention that fall within it.
Yes.
And it would make no sense of 5.3 if in relation to one of the grounds of detention, one of the bases of detention, that is the prevention of an offence, there would never ever need to be a trial.
But 5.1.3 presupposes that the person is in detention. If having been arrested or detained, they are released before they could practically be got to a court, 5.1.3 won't have been breached, will it? Because 5.1.3 requires them to be brought before a court within a reasonable time, and if in less than a reasonable time they've been released, the mischief against which 5.1.3 is aimed has not manifested itself.
Well, let's put that aside then. Let's imagine they haven't been released. Somebody has been arrested on this preventative basis, and they're brought before a court, and the court is then asked to try what? To try whether or not they should be detained to prevent the commission of an offence. For how long? On what basis do they fall to be released?
Well, this was Lord Dyson's question, which was, yes, they've got to be brought before court, but it need not necessarily be for trial. It may be to consider the lawfulness of their continued detention.
Yes. And if the trial is as to the lawfulness of their continued detention, Article 5.1c, read in that way, does not constrain the courts at all from preventatively detaining indefinitely any individual for the prevention of the commission of an offence. Let's look at the third ground of detention, to prevent someone from fleeing after having committed an offence. You've detained somebody because you think it necessary to prevent them from fleeing after having committed an offence. That's the only basis upon which you've detained them. Can't be a 5.1a detention, can't be post-conviction. 5.1a deals with that. So they haven't been convicted. So you suspect they've committed an offence, you're detaining them to prevent them. 5.1c, read together with 5.3 in the way that you're suggesting, means all you need to do is bring them before a court for a court to decide whether or not they need to be detained to prevent them from fleeing. Fleeing in order to do what? To prevent them from fleeing in order to do what? Just to prevent them from fleeing. With no need ever to then bring them to trial in respect of the offence that they are suspected of committing. You cannot read these grounds disjunctively. If the respondent's argument and the Court of Appeal's argument works in relation to preventing an offence, it works in relation to all three grounds.
I'm wondering whether, at any rate, the second of the three grounds in C, the word reasonably is important there, isn't it? When it is reasonably considered necessary. So that isn't that, you say, for how long? It's open-ended. But it's got to be reasonably.
And the court might think it's reasonable
Yes.
to hold somebody for months, years,
Well, why-
year
but
upon year
then
upon year.
Then it would be very difficult for the court to say that that was reasonable. But that would depend on the facts.
It would depend on the facts. And that is, so we're talking about judicial interment here. We are talking...
But Strasbourg doesn't regulate, well, Strasbourg can regulate substantive law, and the question of reasonableness, and indeed lawfulness under Article 5.4, is one on which I can well envisage the Strasbourg Court and Convention judges in relation to which they could well apply standards, as my Lord's suggesting. Common law doesn't allow indefinite detention to prevent commission of an offence, and the Strasbourg Court would certainly say it was unlawful to detain indefinitely for that purpose. We're talking, surely, about short-term emergency measures, aren't we?
Well, that is what this case gives rise to, but we're talking about the interpretation of 5.1c. We're not focusing on what our domestic law provides. This is a convention of
Well, 5.1c would be read in the light of the general presumption that you don't detain people just on suspicion that they might do something wrong in the future. You only detain them in emergency situations to prevent them committing imminently some offence.
And that is
This isn't a general authorisation of preventative or contemplation of preventative detention of an indefinite nature.
And that is what Article 5.1b is there to perform. But the question is, does one need to do violence to Article 5.1c in order to cater for this particular issue of public order policing? And the answer is one doesn't need to, because 5.1b is there and enables you to invoke it. But also, it is just entirely contrary to the clear and constant jurisprudence of Strasbourg, which makes sense of the way Article 5.1c operates, which makes sense of the need to have an anterior purpose, which makes sense of the need of the three grounds.
Yes.
Because I come back again to what does one do about
Anyway,
that?
you've explained how you say Article 5 is to be read, and you've had quite a lot of challenges on that, and you've made your pitch about its proper reading, but then you were going to say that because of the importance of the Strasbourg case law, you need to take us through the critical passages, mindful we have had the benefit of your written case.
So you'd like me to move on to the case law?
Well, I think unless something you more want to say about the structure of Article 5 before you come to the case law, I feel that you've been
It's probably a very good idea.
interruptions for quite a long time.
Can we just take, yes.
Can I just make one more interruption? I see we don't have in our authorities a case called Eriksson against Norway. Can I just...
I looked at that yesterday morning, my lord, and its facts were described by the court as being exceptional.
So it's an example of detention justified under 5.1c where no offence had been committed.
It is. In the end, I thought, given the volume of paper before my lords, I wouldn't bring it, but we can get copies if it would
It might
assist.
be quite interesting. Can I just ask one other structural point, I hope? We're talking, as you made clear a moment ago, about whether this type of situation falls within B or C. And your case on B is that the court has laid down certain limits to the operation of B, which the respondents wouldn't be able to overcome. But, I mean, if the court's going to lay down limits on the operation of B, why don't those limits apply under C? And isn't therefore the real issue, whether you consider it under B or C, what the limits are, and whether they apply to this case?
Well,
Facts.
they operate in such different ways. So the limits, if we're right about Article 5.1c, that it applies in the context of criminal proceedings, then the sort of limits that apply in relation to 5.1b, where one is concerned with fulfilling an obligation, simply wouldn't work in relation to 5.1c.
The limits, as I understand it, are that you have to bring it home in a blindingly obvious way to the person who's going to be detained, that you expect them not to do something, and they have to make it pretty obvious that they are going to do something. Well, when it's reasonably considered necessary to prevent his committing an offence, is capable of being read as precisely subject to any such limits. The real question is whether the Strasbourg Court's limits are what they are, and whether they are as strict as you say, isn't it? Whether you're considering this under B or C.
The real question is whether Strasbourg allows 5(1)(c) to be read in the way that is being suggested. That is,
well,
that it permits preventative detention.
You say so, but I mean, it strikes me as puzzling that one wouldn't be faced actually ultimately with the same question about what the proper limits of the power are. Anyway, let's go on and argue about which paragraph it falls within.
Just a brief look at lawless, which, as we all agree, is only concerned with executive internment. But paragraphs 14, what the court said in paragraph 14 has been said to.
Can you give us a reference?
Yes, I'm so sorry. It's in it's volume 2, tab 8, and the relevant paragraphs is at MSP 1688, internal page 27.
Yeah.
So the first part of paragraph 14 makes clear that the effective for the purpose of bringing him before the competent court qualifies every category of cases of arrest or detention referred to in that subparagraph. So executive detention alone, not permissible. It's 1688. 14 is halfway down that page. And then that's expanded upon. And then the second subparagraph, further, paragraph 1c of Article 5 can be construed only if read in conjunction with paragraph 3 of the same article, of which it forms a whole. It stipulates categorically that everybody arrested and so forth and shall be entitled to trial within reasonable time. It plainly entails the obligation to bring everyone arrested or detained in any of the circumstances contemplated by the provision of paragraph 1c before a judge for the purposes of examining the question of deprivation of liberty or for the purpose of deciding upon the merits. Now, it has been said that what that means is you can either bring them before the court to decide upon the deprivation of liberty, full stop, yes, or to decide upon the merits. And in our submission, that actually simply conveys that what is going to happen on the first time somebody is brought promptly before the court is either you're going to decide on the deprivation of liberty, should it continue, pending their trial within a reasonable time, or you have that trial on the merits.
Well, if we're looking at what words mean, that's not what it says.
Well,
as a matter of plain English, it's perfectly clear that it is putting them forward as alternatives, isn't it?
Well, but it is an alternative as to what happens when somebody is brought promptly before the court. At that first appearance, there are two things you can do. But it is not saying that if you decide upon their deprivation of liberty, that's the end of the matter. It is saying that those are the two choices you have. Now, read in the context where you are, where the purpose of bringing them before the court is so that they can have a trial within a reasonable time, the most sensible reading of that provision is that you either are ready to go to trial, in which case you try them, or pending the trial, you've got to decide upon the legality of their deprivation of liberty.
But that must be only on the assumption that there is going to be a trial.
Well, exactly, but at that point, when they're brought before the court, it is on the basis that they are entitled to a trial within a reasonable time. There is something they must be tried for. So let's take the third example again. They've been brought they're detained on the ground that you want to prevent them from fleeing. There has to be a trial of something. It can't be the end of the matter that you are going to consider the legality of their detention in order to prevent them from fleeing. It has to be within the context of a wider purpose, and that is to bring them to criminal trial. So that is lawless. Can we then
They refuse to look at the preparatory work, interestingly. 1689, about three-quarters of the way down. They say it's so clear that the court cannot, having regard to the Vienna Convention principles, presumably resort to the preparatory work.
Yes.
And they didn't do so. So,
and you can see further up the same page, you can see what they were rejecting was about roughly 8-9 lines down, was the proposition that anyone suspected of harbouring an intent to commit an offence could be arrested and detained for an unlimited period on the strength merely of an executive decision.
Yes, and I accept they were not looking at what the purpose of bringing the individual before the court was in that case.
Right.
So, next case,
Does
Chiller.
the purpose have to have been in the mind of the person arresting?
Yes,
Why?
because we can see that from Brogan.
Okay.
At the time of arrest, the purpose must have been contemplated and in the mind. And that's one of the issues that we have with the way in which the Court of Appeal found that there was such a purpose here, was by looking at events which took place after the arrest. Chula, that's the same volume, tab 6.
Because you could construe it objectively in the sense that here is a power which is given to enable the following things to be done. And that is not quite the same as whether subjectively the individual exercising the power was motivated in that way.
And in our submission,
You say the authority that issue has been addressed, and the court has reached a considered judgment that it's the subjective and not the objective
yes, that's
interpretation.
Brogan. That must
That's
be
Brogan.
the.
Okay.
So, tab 6, same volume, MSP 1620. This is the Chula case, and this is the first case in which the court spoke about the need for 51C detention or arrest to be in connection with criminal proceedings. Now, this was decided in February of 1989, way before any time at which the chamber and grand chamber system was created. So all decisions were decisions of the court. We can see the composition of the court here. Judge Risdall,
Sorry, MS number?
MS 1620.
Thank you very much.
And it was in fact decided 3 months after the Brogan decision. The facts are at paragraph 10 to 16. We don't need to look at them in detail. The criminal proceedings have been brought against the applicant for drug-related offences. He was sentenced to 11.5 years, but he wasn't detained in relation to that sentence pending his appeal. And meanwhile, an application was made for his preventative detention and ultimately for a compulsory residence order to be made against him. And when the hearing took place on the 8th of May, the prosecution sought detention pending the determination of that application. So it was a judicial decision about his detention. The President of the 6th Division's reasoning is set out at page 1623. And that can be seen in the cited passage. And in paragraph 17, we can see the 6th Division of the court ordered he should be restricted to a specified place of residence for 5 years, and he was then taken to a small town in Ancona. His complaint is at paragraph 24 on page 1625. He said it was in breach. His detention for that period from 8th to the 25th of May was in contravention of the convention, and the judgment, the relevant paragraphs are 37 to 38. I start. So they make it clear, paragraph 40 and the conclusion of 41, also worth reading. Certainly the court does not underestimate the importance of Italy's struggle against organised crime, but it observes that the exhausted list of permissible exceptions in paragraph 1 of Article 5 of the Convention must be interpreted strictly. And it makes it clear that Article 5.1c is concerned only with detention in the context of criminal proceedings.
Right, which paragraph was that?
Detention.
It's 41, yes, sorry,
41.
yes.
If we can then turn to Gethius, or Gessius, that's the next tab on. Facts are at paragraphs 8 to 10 on page 1640, if the court just looks quickly at those facts. Case for murder struck out. Police Commissioner orders 60 days of preventative detention on the authorisation of the prosecutor. That was on the 8th of February. On the 9th of February, that is sanctioned by a court on the basis of Article 51 of the Code of Criminal Procedure. And there's an appeal that is then dismissed. At paragraph 35, the court will see Article 51, the preventative detention power. And there are specific offences that are identified: banditry, criminal association, terrorising a person, and the preventative detention can take place with a review to preventing the commission of such an act. And then it's necessary to bring the person before a judge. There are 3 periods of detention that the applicant complained about, but we are concerned only with the first, which was the detention from the 8th to the 14th of February, of March, sorry, the 8th of February to the 14th of March. And his complaint is set out at C53 on page 1648. Commission's reasoning is at C62, page 1650, through to C66, 65.
Just going back to Ciola, which is referred to there in C65, if you look at MS 1629, paragraph 40 in Ciola, the last 3 lines of page MS 1629, neither the prosecution nor the President mentioned any concrete and specific offences, the only ones which are relevant in regard to Article 5.1c, which Mr. Ciola had to be prevented from committing. They relied on the past serious offences which led to the heavy sentence passed on him by the Milan District Court, and on circumstances which indicated he was a danger to society. So the problem was not that he was being detained to prevent commission of offences. It was because he was being detained, the offences were entirely vague, and it was just that he was a danger to society. If there had been concrete and specific offences, the suggestion seems to be you could have detained him under 5.1c to prevent them.
There are 2 elements to 5.1c, which is that the offence itself, which is the commission of which is being sought to be prevented by the detention, must be a concrete and specific offence, but it also must be in the context of criminal proceedings.
Well, where does it say that in paragraph 40? The whole of paragraph 40 is in the context of the argument whether he was detained because it was reasonably considered necessary to prevent the commission of an offence.
Well, you rely on 38, don't you?
Yes.
I mean, your point is that there are 2 requirements here.
Yes. Exactly. There are 2 requirements. It has to be, the court points out that it's deprivation of liberty only in the context of criminal proceedings. This is apparent from its wording, which must be read in conjunction both with subparagraph A. Subparagraph A, let us remind ourselves, is...
But what does in connection with criminal proceedings mean? I don't know. I mean, that phrase is repeated in 40, and the way I read the sentences I read earlier, it may be that it's in connection with criminal proceedings if you are arresting or detaining to prevent the commission of concrete and specific offences.
No, in my submission, criminal proceedings means exactly what we understand it to mean, that it means putting somebody on trial for the commission of a criminal offence.
So the whole of paragraph 40 is irrelevant, really.
Well-
The further submission didn't need answering because it couldn't arise.
Well, it also, because also the prevention of a criminal offence must in itself be the prevention of a specific and concrete criminal offence in order to justify detention. But criminal proceedings, its meaning is obvious and clear. It is the determination of a criminal charge. It is proceedings whose object is the determination of a criminal charge. And therefore, of necessity, it must be in connection with an offence under domestic law. So Gessius and Lithuania, going back to that, that is the next authority along, and we'd looked at Article 50, and
Sorry,
then
which one are we on now?
sorry, we're the next authority along. Tab
Oh, yes.
7,
Right.
we'd looked at
Yes.
Article 50, and we were going to look at the Commission's reasoning at C62, which is on page 1650.
Yeah.
So you can see they're looking at 5.1, 63, they look at the government's argument relying on 5.1c. And then at 65, however, as the court stated in Lawless, Article 5.1c of the Convention means the person is reasonably considered that a person whom it is reasonably considered necessary to prevent committing an offence may be arrested or detained only for the purposes of bringing him before the competent legal authority. Later, in the Chuller case, the court found that Article 5.1c only applied to pre-trial detention ordered in the context of criminal proceedings, but not to the purely expedient detention at issue. In the present case, since the detention provided for in Article 50 only had the purpose of preventing crime with no reference to bringing the detained person before the competent legal authority, it did not satisfy the requirements of Article 5.1c. And then if we go to 1662, we can see the court's judgment starts there, and if we then move to paragraph 47 through to 51 on 1664. The applicant complained, third line down, there have been no grounds for such custody as no criminal proceedings have been pending against him at the time. Moreover, there were no crimes he should have been prevented from committing. And then the government again rely on Article 50. And then they set out the Commission's opinion at 50. The court observes that a person may be deprived of his liberty only for the purposes specified in Article 5.1. A person may be detained under Article 5.1c only in the context of criminal proceedings for the purpose of bringing him before the competent legal authority on suspicion of having committed an offence. And they rely on Lawless and refer back to Chuller. And
Well, that seems to omit rather a lot of Article 5.1c.
well, it doesn't omit a lot of 5.1c because instituting criminal proceedings requires that somebody be suspected of having committed a criminal offence. They can then be detained on various grounds. Those are the grounds specified in Article 5.1c. But a prerequisite for commencing the criminal process against an individual is that there are grounds to suspect them of a criminal offence. The confusion that arises is because the grounds of detention in 5.1c are equated with the purpose of detention in 5.1c. But the purpose of detention in 5.1c is necessarily an anterior purpose. See 5.1c read in context, particularly with 5.3 and 5.4, and the anterior purpose is clearly a criminal trial, or the conduct of a criminal trial.
Or you would accept, in the context of the English breach of the peace, a binding over order.
Yes, but only because breach of the peace is considered to be a criminal offence for Article 5 purposes, which where the meaning of offence is autonomous. So Schwaber and Germany, same volume, 12. MSP 1786. If we look at the head note very briefly, these were protesters at the G8 summit. H1 and H2 is all your lordships need to read. this was detention that was found to be by the court indispensable and proportionate. And then, if the court can turn to MSP 1797 and look at the government's arguments down to paragraph 64. Important because they mirror the arguments put by the respondent. And 68 after 64. So as we see, it's the same in Ostendorf, the German government was really stuck because it didn't constitute an offence in the same way that breach of the peace constitutes an offence to threaten a breach of the peace. And therefore, it was absolutely necessary to establish that Article 5.1c is not concerned with detention in the context of criminal proceedings, because there was no way they could bring that detention within Article 5.1c, should that be the case. And at 69 through to 72, the court repeated the by now constant case law. Firstly, we get at 69, this is an exhaustive list. No deprivation of liberty will be unlawful unless it falls within one of these grounds. Then, at 70, under the second alternative of 5.1c, the detention may be justified when it is reasonably necessary to prevent his committing an offence. That ground of detention does no more than afford the contracting state a means of preventing a concrete and specific offence. This was the point I'd made before to Lord Mance, as regards, in particular, the place and time of its commission and its victim. This can be seen from both the use of the singular and offence and from the object of Article 5, which is to ensure that no one shall be dispossessed of his liberty in an arbitrary fashion. Secondly, at 71, under the court's well-established case law, detention to prevent a person committing an offence must, in addition, be effected for the purpose of bringing him before the competent court, a requirement which qualifies every category of detention referred to in 5.1c. Subparagraph C thus permits deprivation of liberty only in connection with criminal proceedings. It governs pre-trial detention. It's apparent from its wording, which must be read in conjunction both with subparagraph A, that is, conviction, detention following conviction, and with paragraph 3, which form a whole with it. And then they cite what paragraph 5.1.3 requires, must be entitled to a trial within a reasonable time. And then we'll see all the case law that they cite under their footnotes 25 through to 27, and they include again Lawless and Ireland. And so their reading of Lawless and Ireland is that it is entirely consistent with 5.1c being concerned with detention in the context of criminal proceedings. Because we submit, that is obviously what it means when there is a reference to the need for somebody to be brought before the court to have a trial within a reasonable time, where the very purpose of detention is to bring them before that court. So they then concluded at 79, referring back to 5.1c, that the detention was the court further refers to its long-established case law, again, should have been effective for the purpose of bringing them before competent legal authority in the course of their pre-trial detention and aimed at committing them for trial in the criminal courts.
We'll then go on to say that because of findings on the facts that the detention couldn't be reasonably considered necessary, they didn't find it necessary to respond to the parties' arguments on part of the government advocating a revision of the court's case law.
No, and then that comes later. So that is the
Where
Ostendorf
is that?
case.
In paragraph 79.
Oh, yeah.
So that's what then comes later in Ostendorf, and we can see that all the arguments that the government is now advancing were advanced by the government of Germany in the Ostendorf case. So if we turn to that now,
Just before we do that, in 72, Minister, they say that 5.1c has to be read in conjunction with 5.3. Is there any case in which the 5.1.3 has been complied with, but there has been held to be a breach of 5.1c?
of 5.1, so I'm sorry, where 5.1.3
Where
has
5.3 has been complied with, but there's been a breach of 5.1c.
I'm afraid I can't answer that off the top of my head.
You're not aware of any?
But if there were such a case, it would be a case concerned with criminal proceedings, where perhaps their initial detention wasn't justified, but criminal proceedings were nonetheless brought against them, and a subsequent detention was, or they were tried within a reasonable time. That could be an instance, I suppose. So they might complain that they were initially detained unjustifiably under 5.1c. Thereafter, they were released, but they're complaining that they weren't tried within a reasonable time. That would be an obvious example of where that could arise.
But I mean, once again, one sees in this case that the government's assertion or case was that 5.1c should be read as justifying detention for preventive purpose, if necessary, to prevent a person from committing a concrete and specific offence. And when the court deals with 5.1b, it uses very similar parallel language at paragraph 82. It asks itself whether it says that there must be the obligation prescribed by law must be real and specific, already incumbent on the person concerned and not yet satisfied by that person. And it then interprets B fairly narrowly in the light of that requirement. But if it had held that 5.1c applies to this type of situation, I don't see why it wouldn't have interpreted 5.1c precisely as narrowly as B, because the reasons for interpreting B narrowly are rule of law reasons. In other words, they're reasons which you drew on earlier in saying that people shouldn't be detained preventatively for long periods or except in extreme situations. So really what we ought to be arguing about in this case is not whether it's B or C, I come back to that. We ought to be arguing about what are the proper limits and how they apply on the facts. They're not, I find it inconceivable that the limits would be different if we said that C applied rather than B, or that B applies rather than C. You'd be arguing in what circumstances should preventive detention be possible as a matter of rule of law, bearing in mind rule of law considerations.
In my submission, we can't get away from identifying, firstly, what Strasbourg has identified, these different exhaustive provisions which do different things, as being concerned with. We have to identify that, and then we have to ask ourselves whether we can legitimately depart from that before we then get on to that question. So,
sounds to me a very good argument against codification of the law. As soon as you have codification, as you have effectively by the convention, you spend more time arguing which paragraph you're in than you do about the substance.
that may well be so, but we have a list of grounds of detention which are, the court has repeatedly stated, are exhaustive. The exhaustive effect has been identified for the very purpose of preventing arbitrary detention, and in our submission, it it's also important to recognise that these two provisions aren't doing the same thing. And that is a reason in itself why one should be very cautious about opening 5.1c up to anything other than criminal proceedings, which is what the court has understood it to be concerned with for so long. If 5.1b can permit a measure of preventative detention in circumstances of immediate necessity and where other conditions have been applied with,
I see that. I see the argument.
then don't do damage to 5.1c, where 5.1c's meaning has been clearly identified by the court. And that is our starting point. 5.1c has a very specific understanding. 5.1b is something which can avail the respondent in these circumstances. Ostendorf. Volume 2 again, tab 11. So again, if the court would just look briefly at the head note. 3/4 of the way down the page to when the applicant was released at H. So then, paragraph 49, MS page 1770. Now we have the government's arguments. We can see that the government put every argument forward that the respondents put forward. In the government's submission, the applicant's detention had been justified under 5.1c in the first place, as it had been reasonably considered necessary to prevent his committing an offence. They stressed the applicant had not yet committed a criminal offence, as his preparatory acts arranging a hooligan brawl were not punishable in German law. So they are stuck with a greater difficulty than we are here. And then at 51, in the government's view, preventative police custody as that of the applicant was covered by 5.1c, despite the fact it was not concerned with criminal proceedings as required by the court's current case law, if it was indispensable to avert an imminent specific criminal offence. So it cannot be clearer the narrow contour and confines of the argument they're putting forward, which mirrors what my Lord Mance says Article 5.1c can accommodate. And then they say it's confirmed in the wording of Article 5.1c, and they look through that wording, and the remainder of that paragraph, they formulate their arguments as to why 5.1c should be read to accommodate that sort of preventative detention. They then refer at 52 to the state's obligations under Articles 2 and 3, that is to take itself reasonable measures to protect the lives and the limb of others from the sorts of threats that the applicant in this case was said to present. And then at 53, they argue that the requirement in 5.3 for a trial within reasonable time did not warrant the conclusion that Article 5.1c only covered pre-trial detention. It was true that no criminal trial would be held, but the duty to bring a detainee promptly before a judge, as equally required by Article 5.3, also applied to persons in preventative custody. The term trial in these circumstances had to be understood as referring to the judicial decision on the lawfulness of the preventative custody of the person concerned. Equally, it would be the judicial decision on the lawfulness of the custody to prevent the person fleeing. The argument was there put. The government stressed the possibility at 54 to have recourse to such custody for preventative purposes was indispensable to the police in order to maintain security and order. They absolutely need it. Just under D, the authorisation of custody for preventative purposes was particularly important in cases of imminent domestic violence or where there was a risk of clashes provoked by violent participants or counter-demonstrators in the context of demonstrations of right-wing or left-wing groups. 55, such preventative custody was particularly important in Germany, where contrary to the applicable law in other member states, see us, criminal law punished acts by which an offence was prepared only in exceptional cases. And then at 56, there had been no less intrusive means than the applicant's detention for a short period in order to achieve the aim of crime prevention. The applicant no longer had to be brought before a judge as required by Article 5.3, as a court decision could not have obtained before the end of his short detention. The applicant had been free to obtain a court decision on the lawfulness of his detention after his release. So all put as fully as it could be as to why a change in the wording which the German government accepted was part of the settled case law in Strasbourg, that it is concerned with criminal proceedings. And if we then turn to paragraph 63 of the court's assessment, 63 to 64, the court need not trouble itself, that's concerned with whether the detention constituted of deprivation of liberty. They found that it did. And then at little Roman numeral 2 at G, we get the grounds of detention. And if the court can read 65 and 60 down to 68. So we see a reiteration of the case law and then the application to the facts at 80. And 83 to 84.
I'm sorry, but it may be 70. The last sentence might be quite important in relation to 5.1b.
I'm sorry.
Yes.
The last sentence of paragraph 70 is perhaps important in relation to 5.1b.
In relation to 5.1b?
Yeah.
Yes, we're going to come back to 5.1b.
Okay.
Well, I mean, this is all set out exhaustively in your case, and I think we have, certainly I've been reading what it says about 5.1b. I think we fully see the way in which 5.1b is put, so you needn't come back too extensively to it.
Yes.
I mean, we'll need to focus on the point Lord Reed has just made. What are the conditions for 5.1b? And as I've said repeatedly, it seems to me exactly the same point would arrive under 5.1c.
So, just on for completeness then.
It's 85 is obviously very important from your point of view.
85 is very important because here they address in terms
The revision, the argument for revision, and they reject it.
The argument for revision.
Yes.
and they make the point that preventative, the lawfulness of preventative detention is governed by Article 5.4. And they then carefully, between 85 and 89, analyse the government's arguments and set out the basis upon which they specifically reject the invitation to revisit the interpretation of Article 5.1c, and they make it clear at 89 that the interpretation is based on is a long-standing interpretation of the court.
Presumably you'll come to the minority judgment.
And then coming to the minority judgment, if we turn to page 1784, at 1784 at D, and this is the majority judgment, we can see Judge Lemons and Jederblom, who concur.
Or
but their
concur in the
reasoning-
result.
They concur in the result, their reasoning is very different, and they observe at D, the majority, third line down, it follows from the wording of the provision, of that provision, that is 5.1c, in conjunction with 5.3, that a preventative detention can only be justified if it is effected for the purpose of bringing the arrested or detained person before the competent legal authority, understood in the sense of bringing him to trial. The majority specifies that a preventative detention is permitted only in connection with criminal proceedings. And that spells out very clearly what is meant by in connection with criminal proceedings. The
Where are we reading then?
This is at D on 1784.
Yes, I see, yes.
What is meant by the purpose, effective for the purpose of bringing the arrested or detained person before a competent legal authority is, as I have been submitting, the purpose is to bring them to trial for a criminal offence. And the grounds upon which the person can then be detained for that purpose are those three grounds set out in 5.1c.
Yes, but then they go on to say that in their view this case law's gone too far, it departs from what was said in Lawless, and they then develop on 1785 an alternative analysis.
They do. And in fact, the analysis they then develop is very similar to the analysis that the Court of Appeal adopted.
It would be open to us to prefer it, wouldn't it?
Well, in my submission, no, it wouldn't be open to you to prefer it, and that is both because there is a very long line of authority that is established that this is the position, and as we'll see, it is a line of authority that has been repeatedly endorsed by the Grand Chamber.
We have taken into account, but where there's a division of view there, if we, having taken it into account, prefer the view of the minority, why shouldn't we have followed
Well, in my submission, that's not the basis upon which this court has said a departure is permitted. It's not simply that other views are expressed and there are dissenting judgments. Mm-hmm. It is that within the court structure itself, you have different chambers coming to different views, leaving it open for a genuine choice to be made. But we're not in
Well, I don't think we've ever precisely tied ourselves to a codified formula which we have to construe. But I suppose the question would arise whether it was a good idea to disagree if there's B available and if the court has set limits to B,
which are workable.
which would similarly apply to C.
Well,
anyway.
Was there any suggestion that this case should go to the Grand Chamber? What the mechanism would have been? But Germany clearly felt very strongly about it.
Yes.
Germany had won. They won the case.
They won the case anyway.
Germany won the case.
Right.
Yeah,
Germany won the case.
yeah. Anyway, as far as you know, that hasn't happened. No one
No.
knows.
It hasn't gone. But as we said, there is a recent decision that has endorsed it in the Grand Chamber, and obviously they didn't. It wasn't absolutely. It wasn't in issue, but it was considered. But
No, I mean, the point about Ostendorf, from your point of view, is it's so similar in a way factually to the
Yes.
situation we have.
and all the arguments that the government can put
Yeah.
here were put, or the police can put here. Can I just go through a number of Grand Chamber decisions which do also endorse
Well, you've got more
Chiller
in the case,
approach?
haven't you?
Well, A in the United Kingdom, I'm not sure we've mentioned it. Just
But is it in your case? Can't we take them?
I don't think A is in our
I
case.
think we've got that separately.
Yes, you've got it separately there.
if we're looking at
Or has it just arrived?
if we're looking at the substance of the minority opinion, paragraph 5 on page 1785 and the second paragraph starting in one of the guarantees perhaps merits our attention. You don't need to read it out, but it's an interesting point, interesting argument which is there being developed.
Actually, again, the risk of repeating the point excessively, if you look at the fifth line in paragraph 5, the minority makes the point, we think that a number of the conditions that the majority lists under 5.1b are also relevant for a preventive detention under 5.1c, which brings me back to the point that at the end of the day, we're going to be arguing about what limits apply whichever subparagraph we're applying. I.e., what are the proper limits under Strasbourg law to preventive detention? And do they apply on the facts of this case?
But it will still be necessary to examine it through the prism of Article 5.
Well,
Is there a flaw in the point at 764G? Be helpful for you to indicate if there is, where they say an early prompt release without appearance before a judge or judicial officer may often occur frequently in case of administrative detention for preventive purposes. Even so, in such situation, it will be enough for the purpose of guaranteeing the rights inherent in Article 5 if the lawfulness of detention can subsequently be challenged and decided by a court of law. Is there a flaw in that reasoning conceptually?
No, in my submission there isn't a flaw, and that would be something which is important for considerations of detention under Article 5.1b, where one is concerned with forms of administrative detention. Under Article 5.1c, one is concerned with detention in the context of criminal proceedings. They are different provisions concerned with different bases and circumstances.
You've got to, under Article 5.4, have a speedy procedure so that if you are still in detention, that can be, the lawfulness of that can be determined. But if you're released early, then you're still entitled to go to a court and say, I wasn't released early enough.
And that can fulfil the purpose for which the article is there, and the purpose which the arresting person may well have in mind that that the system provides.
Right. We've got to look at some other cases.
So A in the United Kingdom, paragraphs 171 to 172. This was the Belmarsh detainees case. And the difficulty that the government faced in relation to this case was to try and bring the detention within Article 5.1f. And the importance of this passage is the court's focus on the exhaustive nature of the permitted grounds of detention, and that even the threat of terrorism, the serious threat of terrorism in the post-9/11 world does not justify a departure from the court's constant case law as to the interpretation. So it's important to see that the court itself applies a very strict approach to the interpretation of Article 5.1's categories of detention, even in the face of a terrorist threat. And then if we can turn to A in the United Kingdom, that is in Volume 4, tab 43. Sorry, Al Jeddah in the United Kingdom, I'm so sorry. Volume 4, tab 43. And Al Jeddah concerned the detention of Mr. Al Jeddah in Iraq in the post-occupation phase from October 2004, at which time his detention was authorised by a UNSCR, which authorised his internment, and a challenge was brought under Article 5 on the ground that there was no lawful basis for that detention, and the UNSCR did not provide that basis. At 99 to 100, the court again emphasises the fundamental nature of Article 5, the exhaustive list of permissible grounds that it provides for, that it doesn't allow that it remains in place unless there's a lawful derogation. And then at 100, it's long been established the list does not include internment or preventative detention where there is no intention to bring criminal charges within a reasonable time. And they then make reference to Jethius and Lawless again and Goodsardi. So there is a specific reference by the court that it is concerned with criminal proceedings.
Well, it's saying this is not allowing internment without an intention to bring criminal charges within a reasonable time.
Well, it's referring to Jethius. Well, yes. Jethius makes clear that it is concerned with criminal proceedings. And that is what 5.1c governs, detention during the course of criminal proceedings.
But I mean, this is an internment case where he was kept in internment.
Well, it also says preventative detention as well, 100. It does not include internment or preventative detention.
I mean, this is the context of a case of somebody who'd been detained for 3 years.
Well, it is the context, but what they are making clear is that it doesn't allow preventative detention or internment where you're not intending to bring criminal charges. That is, it couldn't be made clearer. You've got to be bringing criminal charges. They refer to Jethius. They don't seek to narrow the ambit of Jethius or say that it is only internment that is prevented.
No,
but not
I mean, simply the obvious point is they're just not addressing the exercise of emergency powers in a situation of short duration.
Yeah, they're not addressing it, but what they're making abundantly clear is that Article 5.1c is concerned with criminal proceedings. That's how it's been interpreted for a long time, and they're endorsing that. And so we need then to look at the circumstances that can justify movement from the constant case law of the court.
Yes.
Lock-in and Russia, I know that the court, we've made detailed submissions in relation to that. The Chamber considered in detail 5.1c, and the Grand Chamber at 1654 and 165.
Sorry, you haven't given us a reference to this.
I'm so sorry, I wasn't going to take your lordships to it because of time, but the reference is it's the Chamber decision is at 14b.
What's the tab or what's the page? MS number?
Volume 1,
yes.
tab 4b, MSP 1512.
Right, 1512, thank you.
Yeah.
And
first section decision.
This is the first section, and the assessment of the court begins at 116, and then the relevant paragraphs are at 117 to 120.
Yeah.
And in relation to the Grand Chamber, that's at Volume 1, tab 4A, and the relevant paragraphs are 154 and 165.
Right.
And then finally, on Grand Chamber decisions, the case of Austin, which started life obviously in the United Kingdom. Austin was the Kettling case. So it was the case where
Oxford Circus.
Yes. Containment for 7 hours, and the question was...
Well, they held it was out with Article 5 altogether.
They held it was out with Article 5 altogether. It was not a deprivation of liberty, but one can see why that happened. If we look, for example, in the House of Lords judgment, Volume 3, tab 20, very brief look at the judgment of Lord Hope and Lord Newburger. It was in recognition of the difficulty that would otherwise arise in trying to bring this measure within Article 5, if it was a deprivation of liberty. So at 35 in the judgment of Lord Hope...
Doesn't sound a very good reason for saying it wasn't within a deprivation of liberty, but still shows the passages.
It's 35 to 37.
upheld. The European Court accepted this.
Yes, I'm just going to come to that very quickly in a moment. So we can see Lord Panic didn't even develop the arguments on 5.1b and c because of the obvious difficulties. And then in the speech of Lord Neuberger at paragraph 64, again, we can see a recognition of the difficulties faced with such an argument. And then if we come to the Strasbourg decision, volume 4, tab 42, can we start with paragraph 53? So the need to treat the Convention as a living instrument does not, however, mean that to respond to present-day needs, conditions, views or standards, the Court can create a new right apart from those recognised by the Convention, or that it can whittle down an existing right or create a new exceptional justification which is not expressly recognised in the Convention. And it then cites Chulow as an example.
Have to take that
And
with a pinch of salt, doesn't one? Doesn't one have to take that statement with a pinch of salt?
And that will, on what basis, my lord?
Well, it certainly created extensions of the Convention. It certainly created new exceptions. We'll come back to Hassar.
We'll come back to Hassar. We'll come back to that.
Right.
56. It's a recognition of the need for the police to be able to police practicably and to fulfil their duties of maintaining order and protecting the public. They recognise that principle at 56.
Well, we have to be loyal to this decision, but it's a pretty, some might think it's quite a surprising decision, and that there might be something to be said for the dissenting view. You detain someone in Oxford Circus for 5 hours, and to say it's not a deprivation of liberty seems to me quite odd, but still, there we are.
It remains a decision of the Grand Chamber in which they refuse to depart from their constant Caitlin's law on the interpretation of Article 5.1.
So what's it relevant on anyway, for present purposes?
In paragraph 60, we get again an indication that the list is exhaustive.
Yes.
And in the dissenting opinion of Judges Tulken, Spielman and Garlicki at 019, page 2232, they identify the paradox.
Sorry, where do they do that?
019, sorry, paragraph 22, page 2231.
There isn't an 019.
Page
Yes,
2231.
2231.
Oh, 2231. Right.
And they just identify what the problem is, because on the Court's clear and constant jurisprudence, you just can't bring this measure within Article 5.1. So, yes, I accept that what the Court then did is it reached a very, very surprising conclusion about deprivation of liberty and what it means. But what they refused to do was to change the interpretation that has been given to Article 5.1 itself. And that's why they were forced, therefore, to find that Article 5.1 wasn't engaged at all.
Well, I mean, that is very odd reasoning, and it does throw doubt on the basic reasoning. It throws doubt on the proposition that Article 5 is really as narrow as you're suggesting. If it really leads to the consequences that you have to hold that something isn't a deprivation of liberty when it obviously, one would have thought it might obviously have been. One doubts the premise, but still.
And our House of Lords reached the same view.
Yeah.
Exactly the same view. It's not a deprivation of liberty. So all that the Strasbourg Court did was follow the domestic court on that front. Yeah. We then need to turn to the decision of the decisions that are being relied upon by, or were relied upon by the Court of Appeal to justify its decision which we submit as marks.
Could you at some moment just give me the reference in Brogan to the holding that purpose is to be construed subjectively?
I was just about to come on to Brogan.
Okay.
So it's at volume 1, tab 5. And this decision was a mere 3 months before the decision in Chula. It was, as the court will see, the composition of the court was almost identical. So when the court 3 months later said that Article 5 is concerned only with criminal proceedings, Article 5.1c, it's more or less the same court that was saying it in the Brogan, as sat in the Brogan case. And Brogan is unquestionably concerned with criminal proceedings. It was an arrest, and the whole issue arose in Brogan because these individuals were arrested under Section 12 of the Prevention of Terrorism Act. They were then released without being brought before a court and never charged. And they said, well, our detention therefore fell outside Article 5.1c because we weren't brought before a court and we were never prosecuted, so it couldn't have been a 5.1c detention. And so the two bases of challenge are set out at the end of paragraph 49. On page 1583. They were not arrested on suspicion of an offence, that was their first argument, nor was the purpose of their arrest to bring them before a competent legal authority. And they complained about it, they're not being arrested on suspicion of an offence because of the wide powers, they said, that existed under under the Prevention of Terrorism Act. And 50 to 51 deals with that first complaint, and the court rejected the argument that they weren't arrested in connection with a specific offence. And then 52 to 53 are the key passages. It also requires that the purpose of the arrest or detention should be to bring the person before a competent legal authority. The government and the Commission have argued that such an intention was present and that if sufficient and usable evidence had been obtained during the police investigation that followed the applicant's arrest, they would undoubtedly have been charged and brought before trial. So it's focusing on the actual circumstances that arose. And the court refuses then to examine the impugned legislation in abstracto, but must confine itself to the circumstances of the case before it. That's at 53 at the beginning. And then it says the fact the applicants were neither charged nor brought before a court does not necessarily mean the purpose of their detention was not in accordance with 5.1c. As the government and the Commission have stated, the existence of such a purpose must be considered independently of its achievement. Article 5.1 does not presuppose that the police should have obtained sufficient evidence to bring charges, either at the point of arrest or while the applicants were in custody. Such evidence may have been unobtainable or, in view of the nature of the suspected offences, impossible to produce in court without endangering the lives of others. There is no reason to believe that the police investigation in this case was not in good faith or that the detention of the applicants was not intended to further the investigation by way of confirming or dispelling the concrete suspicions which, as the court has found, grounded their arrest. Had it been possible, the police would, it can be assumed, have laid charges and the applicants would have been brought before a competent authority. And in our submission, it's clear from that one is looking at what the subjective purpose was behind those who are arresting and conducting the or dealing with the individual post-detention.
This goes to the question of facts. Is there any reason to doubt that the police intended to have brought them before a court in the unlikely event that they would have been there long enough to bring them before the court under Article 5.3?
Well, this was the way in which the Court of Appeal reasoned, and they reasoned that because the police would have known their obligations in relation to breach of the peace, then had, for example, matters taken an unexpected turn such that they weren't able to release them when they originally intended, they would have brought them before a court, and from that you can infer the detention at the intention or the purpose of bringing them before the court at the outset.
But if there was an intention to comply with 5.3, if they were there long enough to do so, Is that sufficient as a matter of law?
No, in our submission, no. You need a specific intention to, at the point of arrest, to conduct an investigation in order to see whether or not the bind over that you're contemplating is something that ultimately it is appropriate for you to bring. And so if we're right on the facts, of this case, that there never was an intention to do anything other than hold these individuals and then release them once the celebrations were over, then the purpose of arresting them in order to bring them before the court for a bind over simply wasn't there. And the fact that there might have been a need as a matter of law to do that had events developed subsequently does not form the basis of either the existence of the purpose at the time of arrest or upon which it's permissible to infer.
What's the purpose of going through the PACE procedures, recording the reason for detention, etc., other than to enable a court to adjudicate, either if they are still in custody or, in the alternative situation, canvassed in one of the authorities, post-release, but still for the purpose of determining the legality? Why else do they, as it were, or is that not a fundamental reason for the recording of those details, to enable the detained person to know the reasons, to consider the strength of his case for challenging it, and to enable a court to adjudicate?
Well, that is, of course, why these processes have been built up, and that's why, albeit PACE doesn't apply to breach of the peace, the courts have repeatedly said, well, it would be a good idea to apply it. But the question for our purposes is, does the fact that those steps were taken in relation to these individuals indicate that their purpose at the time of their arrest, the purpose really was to take them through that process? Or was it, as we submit, simply what the police do if they're presented with something?
My question was a slightly different one, which is, we're looking now, because if you're looking at subjective intent, you're looking at a question of fact. Is there reason to doubt, as a matter of inference from their recording those details, from applying PACE, although PACE didn't strictly apply, that they had a purpose to enable the court to determine the adjudication?
Yes, and my answer to that is that, and you will have seen it in our submissions, but that if one looks at the evidence overall, and particularly where both the arrest and the decision for arrest was grounded and where the decision to release was grounded, that in reality and in truth, this was purely preventative detention.
But the two aren't mutually inconsistent. They can intend it to be short-term preventative detention, but also intend the court to be able to adjudicate on it and complete all the necessary details for that purpose. And there are two questions then. One, as a matter of fact, whether it's to be inferred that that was their intention, and two, if it was part of their purpose, whether that's adequate for the purposes of the
Absolutely.
Of Article 5.
Absolutely, in our submission.
One's a question of fact, the other's a question of law.
Yes, exactly.
And I think I know what your answer on the point of law is, but I was just testing your response on the point of fact.
Yes, and our submission on the point of fact is that, in fact, those steps were simply formalistic responses on the part of the custody sergeant who, whenever presented with somebody who is arrested for a breach of the peace, will automatically open a custody record and go through the process, irrespective of whether or not actually there is an intention to investigate that individual and bring them before the court. It was simply a formulaic and formal response without any substance lying behind those steps, which demonstrated or manifested any intention.
It's most unlikely. I mean, your case is presumably it's most unlikely they were thinking of getting a bind over because at least hopefully royal weddings don't happen every day.
Precisely. And that, and we can see it most clearly in relation to the individuals who never even got into the police station. I mean, most of the Charing Cross individuals never actually got in to have a custody record opened in relation to them.
I mean, anyway, there we are.
And the point about royal weddings not happening every day is, it cuts both ways. I mean, the practical problem here is that on your interpretation and the one that the court appears to have adopted, preparatory acts which don't go so far as to involve the commission of an offence themselves aren't enough to justify detention. And so the answer has to be you have to keep an eye on the person until they actually do something which amounts to the commission of an offence. And at that point, they can be detained. That simply gives rise to an obvious practical problem.
That's only under C, though.
Yes, under C.
Not under B. I mean.
It's only under
well,
C.
B's got its own problems.
Well, certainly.
But under C, obviously the practical problem is an event like a royal wedding, you've got colossal policing responsibilities, and keeping track of all the protesters or potential protesters until they actually commit an offence is that's the last thing the police need to deal with at a time when they're trying to keep an eye open for much more serious possible risks.
But there are many, many measures available to the police, for example, containment and kettling of large numbers of individuals, which means you don't have to keep an eye on them. You can even contain innocent individuals who aren't threatening a breach of the peace. There are measures...
Wait a minute. You're saying that instead of taking them into custody, they should have surrounded them by 10 policemen and kept them there for 5 hours.
Well, that would then have meant that at least they could continue their protest. They would
if
not...
if the law really is that you can have 10 policemen standing around and that's legitimate, but you can't take them to a police station, it's completely balmy, isn't it?
In our submission, it isn't completely balmy. What they can then do is they can continue their protest, they can continue to be there and express their own rights to freedom of assembly and expression, which is why they were there in the first place.
So you'd have to multiply the police force by about tenfold to undertake
Their
that.
failure was their fault lay in actually arresting and going through the legal processes, because if they'd simply locked them up in a yard somewhere, they could have said that's not detention, that's kettling.
Well, it depends where. It depends where they'd lock them up. If they'd taken them off and locked them up in a yard somewhere, that would
If they
probably
can't
be
take them to
detention.
a yard, they can only only lock them up if they happen to be in a yard.
Yeah. So simply shut off everybody in Soho Square, for example.
Yes.
Then fair enough.
That's one example. That is one
I
example.
mean,
and we'll see that they've
ultimately
actually
we are
prepared for that.
responsible for making sense of the common law. The convention rights are supposed to be part of the common law, and if there comes a point where the convention, as interpreted in Strasbourg, leads to ridiculous results, we aren't obliged to apply then.
Well, that's when the court has to ask itself whether construing Article 5.1c, as we submit the court has, together with Article 5.1b, as the court has in Ostendorf, produces absurd results. And in our submission, it doesn't. If you simply say to an individual who you consider is threatening an immediate breach of the peace, you stay there, you don't move, and then they show by their conduct that they're not going to be prepared to do that, you can arrest them. All you need to do is give them a warning, which is what the police do in any event, in all these situations. We can see it from the case law we've cited. Because if the threat of a breach of the peace is really imminent, well, there are two things that are clear. If the threat of a breach of the peace is so imminent, firstly, you'll be entitled to arrest if the person is actually in the process of threatening another or being threatened by another. You can then arrest unquestionably in relation to for the purpose of seeking a bind over, because the situation is such that it would justify it. Alternatively, if we're not dealing with that situation of immediacy and immediate necessity, let's look at the Soho Square people, let's look at all the people involved here. Why can't one say to them simply, you stay where you are? You're not going to go...
Sorry, where this leads to is you say that neither Article 5.1 C nor 5.2 authorised detention under convention law, and notwithstanding that the courts below held that there was a lawful exercise of common law power, in convention eyes they ought to have been not detained and told that they were free to go along, but please don't cause mischief.
No.
Is that, well, what in practical and real terms could they have done, which was convention compliant?
So under 5.1b, what they could have been told under 5.1b. So 5.1c, if the intention was preventative detention throughout, they couldn't be arrested. Under 5.1b, if they had been told, I am very sorry, but you are not going to continue your movements today, you're going to stay here, and had they stayed there, no problem. Had they manifested a refusal to comply with the order they were given, which was given in order to prevent a threat of a breach of the peace, they could then have been arrested.
So they could have been ordered to stay where they were.
They could have been ordered to
And
stay
the
where they
moment
were.
they moved a yard, they could have been arrested.
As soon as they decided that they were not going
But
to...
that would lead, what, to effectively 10 policemen having to stand there watching them for the rest of the royal wedding,
Well,
5 hours.
it would lead to either a situation in which they would have been, for example, those in Soho Square would have been kettled, as there were preparations to do, and we can see it we could see there were clear preparations, and it was clearly anticipated that people would be able to continue their protest in Soho Square by being kettled, and there were provisions of police officers there to do it. It was part of the plan. Or you have a police officer standing along with them saying, and calling for backup if they showed any intention.
But if they don't, and they say to themselves, we don't think there's one police officer going to stay here for the next 5 hours watching us, so we'll just wait. And when the policeman goes, then there's nothing to stop them going.
Well, the policeman isn't going to go, and they then
No, but that's the practical problem, isn't it? If with each of these people, in respect of whom there is a common law power, because of an imminent breach of the peace, the policeman's got to stay there, then you've got the practical problem to which Lord Reed was averting. And I'm just wondering whether there's a practical solution to that practical problem. Maybe you say, well, that's tough.
Or you make plans. If you know that you are not going to be able simply to arrest people on purely preventative grounds, you make plans for their management. And in fact, plans were made for their management. It was planned that there would be kettling in Soho Square. It is something that the police deal with day in, day out at protest situations. And we haven't seen people being arrested like this in protest situations. We've seen people being kettled. And there have been numerous large-scale protests since the Austin case, where kettling has provided a means by which people have been detained without them having to be taken to police stations.
I think
and
being
put in
kettled
cells.
is potentially much less pleasant than being taken to a police station. There are facilities at a police station, as I understand it. Kettling can be extremely disagreeable experience.
That does prompt the thought that you did say at the outset, the purpose of these proceedings was A, to establish an important point of principle, B, to establish compensation. The point of principle would appear to be that they should have been kettled, not arrested, and the compensation would, I suppose, be assessed by reference to what they've suffered over and above what they would have suffered by being kettled. Is that an unfair comment?
That may well be so. Another point to make in relation to resources is, of course, if they are arrested, the arrest involves resources. Of course it involves resources. The arresting officer has to go with the person arrested and take them back to the police station. So it's not as though this is a resource-free alternative. Of course it isn't.
Right, so where do we go next?
So can I just look at two cases, the Steele case and the Nickel case, which are relied upon also by the respondents and by the court as somehow supporting a different reading of Article 51C. Steele first, because that is referred to and relied upon in Nickel, which is the more important case, I think, for the respondents and court's purposes. It's at Volume 2, tab 13. So in the head note, we can see that there were 3 groups of applicants who were all arrested for breach of the peace in the context of protest, and all of them were taken before a magistrate's court and bound over. So the first applicant was with 60 others. It was a grouse shoot, and she was arrested for impeding the progress. She was detained for 44 hours, released on conditional bail, charged with breach of the peace, and we can see she was then dealt with by the magistrate's court. The second applicant took part, the next paragraph, in a protest against a building extension of a motorway, repeatedly broke into the site, arrested while standing under digger, and detained for 17 hours. Magistrates found conduct likely to cause a breach of the peace had been made out. And so too, if you look at the third paragraph, with the third, fourth, and fifth applicants handing out leaflets protesting against fighter helicopters, and they were taken to the station and brought before the magistrates' court. So, in fact, everybody in this, all of the applicants were brought before the court. If we then turn to paragraph 46, we see the court there identifying that breach of the peace proceedings are criminal proceedings for the purposes of Article 5(1)(c).
So what page is 46
Sorry,
on?
it's 1844, paragraph 46.
Okay.
46 to 50.
Yes, right.
So they are criminal proceedings, bearing in mind at 49 the nature of the proceedings in question, the penalty at stake. The court considers that the breach of the peace must be regarded as an offence within the meaning of Article 5(1)(c). The court therefore finds that each applicant was arrested and detained with the purpose of bringing him before the competent legal authority on suspicion of having committed an offence or because it was considered necessary to prevent the commission of an offence. So they were brought before the court in respect of criminal proceedings on these two grounds. And we see that that language of being brought before the court on suspicion of having committed an offence or because it was considered necessary to prevent the commission of the offence was repeated in the Nicol case, simply recited in the Nicol case, and that's in tab 10 of the same volume, 1746. It's an admissibility decision of the fourth section. And if we look at the facts at 1747, this was an anti-fishing protest, which was taking place on the morning of the Saturday, the 28th of May, and we can see 5 lines down. The intention of the applicants was to effect a sabotage of the angling match by preventing fish from being caught. They approached some anglers, explained they didn't want to cause any damage or violence, but they intended to frighten fish away. They threw twigs. They contended that no violence or threats of violence against persons or property took place. Police officers arrived, this is the second paragraph, told the applicants to cease their behaviour, so they were warned. When the applicants refused, they were arrested along with 2 other protesters for breach of the peace. And those arrests took place at 12:25. Detention was authorised, the reason stated on the custody record being to allow a period of calming and to determine method of processing. Now, what we'd say about that is that it is entirely clear from those facts that there was, at that time, a conditional purpose of bringing them before the court. And they were, in fact, brought before a court. They were then detained at the police station, and we can see at the top of page 1748, they appeared before Teesside Magistrates Court on 30th of May, and they adjourned the case, and they were then released. So
It is the position, is it, that when the police arrest someone for an actual or threatened breach of the peace, the magistrate has jurisdiction, if the person is brought before the magistrate, to bind over, either because of the actual or threatened breach of the peace or because of the risk of future breaches of the peace or offences. But is it the fact that there's no obligation on the police to bring somebody who they arrest for breach of the peace before a magistrate?
no, there is an obligation upon them to bring them before.
There is an obligation.
There is an obligation to bring them before a magistrate, but this is at the first available opportunity.
But
And this,
didn't...
Well, unless
not
they
if
let
they
them go.
release them, of course. It's
Right.
Unless they release
yes,
them.
they can. Of course, they can release them. They can investigate them.
Yes, I see. So there is the answer
decide-
is there is no obligation necessarily. It's only if they don't release them.
No,
Yeah.
they could investigate and say, well, actually, we think there is no
I think I touched on this in Wilkinson, didn't I?
Yeah.
Williamson. Yeah.
Williamson, I'm afraid, yes. Because if they don't, then the detention is unlawful.
Yes.
Common law.
Yes. Exactly. But
Yes,
if on
unless they release
examination,
Unless they really,
Yes,
but if they
quite.
continue to.
Yes, quite. Yes, of course. No, I just wanted to check.
so
Because this whole problem would not arise if there was an obligation in every case to bring them before a magistrate before release. The present problem would not arise because every arrest for breach of the peace or threatened breach of the peace would involve an intention to have a trial. the magistrate would have to consider what to do.
Well, then I suppose all one could say in that situation is there may be an argument that it was a 5-1 arbitrary detention in circumstances where, for example, there was absolutely no basis upon which it could reasonably be concluded that a bind over might be necessary.
There's no difference in this respect between arrest for suspected breach of the peace and arrest for any criminal offence, because if somebody may be arrested on suspicion of committing a criminal offence, he may be released by police on bail, or they may decide, having arrested him, they're going to take no further action. It's only if they continue to detain for long enough to bring into play the obligation to bring before court and within a reasonable time that they must then do so.
Yeah, exactly. So it's the same. It's governed by Brogan. So, but what you've got to have is a conditional intent, or the purpose, which can be conditional, must be to set the criminal process in motion by seeking a bind over at the point of arrest. So,
Does it mean, as a matter of interest, that if they arrest on suspicion of having committed an offence, and what they intend to do is to ask the suspect questions and then release on police bail in any event, that would automatically contravene Article 5, because from the outset their intention was to arrest on suspicion of having committed the offence and then release.
Yes, but that's the release, because what Article 5.1c governs, the purpose that is a prerequisite, is a purpose of bringing them before a criminal court. There is nothing wrong with arresting somebody in order to further your investigation, which, if it is furthered in the manner that you are hoping for, will result in charges being made. There is nothing wrong with arresting and detaining for that purpose, and thereafter granting bail, as long as you are then continuing your criminal investigation or have decided on the basis of the interview that charges are not appropriately to be brought.
No, but if the decision is made, what we must do is the plan is arrest on suspicion, interview, and then immediately release. Would that necessarily involve a contravention of Article 5?
No, in my submission it
And that's because you say purpose of bringing before the court. It doesn't have to be bringing before the court as somebody in detention. If the purpose may be to arrest, the purpose is to release immediately after they've answered the questions, come what may. But as long as there may be a contingent purpose at some later day to bring proceedings by way of an information, that would fulfil Article 5.1c.
So as long as the reason why you are detaining them in the first place is to further your criminal investigation, which is being conducted with a view to bringing criminal proceedings, should that prove appropriate, then you are entitled to detain, everything else being equal, because Article 5.1c, as with Articles 5.1a through to F, requires that the detention itself should be justified as proportionate on any one of the grounds that you've identified.
And therefore, bringing before a court does not mean bringing before a court in custody. It simply means referring the matter to a court, whether they're in custody or at liberty is neither here nor there.
Yes. The purpose of bringing before the court is the purpose of putting them on trial for a criminal offence. And this is concerned, 5.1c, with the detention of individuals for that purpose, but it doesn't require that an individual be detained. All it is doing is saying that where an individual is detained, then it is permissible where the purpose of that detention is ultimately to bring them before the court for a criminal trial. In these circumstances, that is where the grounds of detention are any of A, B, and C, the three possible grounds.
Right,
So,
where do we go next?
We were just in the middle of looking at the Nickel
All
case,
right, yes.
and we can see at paragraph page 1752, at the bottom, the challenge by the applicants, they allege their arrest and initial detention violated Article
Yes,
5.1, 1753. We can see the basis upon which they said it. In particular, they contend under the quoted passages that it was incompatible with 5.1c or in the alternative 5.1b, and they set out the basis upon which they say there was a violation, and that was that there was no reason to detain them for as long as they were detained, i.e. it was a disproportionate detention. This comes back to the point we were just talking about. There was no fishing competition the following day. There was no reason for detaining them, and the detention wasn't valid. What they don't argue is the detention was unlawful because it was out with Article 5.1 on the basis that it was a purely preventative detention. They never argue that. And that
Well, you say the reason is that it was always intended to bring the matter before a magistrate.
Absolutely. It was always intended. And then if we look at the reasoning that leads to the passage that the Court of Appeal focused on, it's the next paragraph on 1753. The court looks at the Steele case.
Yeah.
At the very last sentence in that paragraph, the court found that each of those applicants was detained for the purpose of bringing him or her before the competent legal authority on suspicion of having committed an offence or because it was considered necessary, i.e., as we know, see Steele in the context of criminal proceedings. And the very next line, the position is the same in the present case. And so they're simply referring back to what the court said in Steele were the two bases of detention in the context of criminal proceedings, and everything that then follows in the light of that. So when we see at page 1754, the bottom of the paragraph, the first paragraph on that page, 6 lines up from the bottom, the initial detention was to prevent the applicants from committing an offence as regards the period of detention after the fishing match on the following day or throughout the period subsequent to the initial fishing competition. If there was none on the second day, the applicants were clearly being detained for the purposes of bringing them before a competent legal authority. Now, Article 5.1c permits, in the context of criminal proceedings, that you could be detained on one of those 3 grounds. All this shows is they were so detained, initially on a preventative ground, thereafter on the ground of reasonable suspicion, so that they could be brought before the court for a bind over. It does nothing in our submission to support the Court of Appeal's position or the respondents. Hassan and the United Kingdom.
I mean, it does amount to this, does it? What is the purpose in Article 5.1c of the words following the word or when it is reasonably considered necessary to prevent his committing an offence or fleeing after having done so? There isn't, on your case, there isn't any purpose in those words, is there?
So there is, because Article 5 requires detention not only to be permitted under these grounds, but to be proportionate and not arbitrary on these grounds. Now, what that means is that in every case, it's not going to be possible to justify detention on grounds simply of reasonable suspicion, because it may be the offence is too trivial. But it may be that one of the other permissible grounds can then avail the state and justify detention. And we can see this, for example, in the cases of Kudler is an example in relation to Article 5.3, but there are cases, let me just, in volume 5 and 6, it's Ladent, which is at volume 5, tab 54. This is a good example of the need to justify so if that's 2740, if the court then turns to paragraph 54 in Ladent, key passage at 55. For the court, detention pursuant to Article 5.1c must equally embody a proportionality requirement. It will be recalled that in this case, which I'm not going to be able to pronounce, the court applied a proportionality test to detention falling under Article 5.1c when considering whether the applicant's detention on remand was strictly necessary to ensure his presence at the trial and whether less stringent measures could have been sufficient for that purpose. A similar test is applied in relation to Article 5.3, and we can see the reference to Kudler there. In the present case, the court observes that the applicant was not duly notified of the private prosecution proceedings against him, yet the Krakow District Court decided to penalise him for allegedly evading justice in circumstances where the applicant was unaware of the proceedings against him. The court is also troubled by the District Court's conclusion the applicant did not have a permanent abode. It also notes the District Court ordered the applicant's detention in a trivial private prosecution case concerning the alleged slander of a building administrator. And similarly, in Lysenko, at 56 of volume 6...
But what are we getting out of this? I mean, it's obvious that proportionality is necessary before you arrest or detain anyone.
No,
but
the point is that all Article 5.1c does is it identifies the permissible grounds of detention. They are not necessarily sufficient grounds of detention. So to say that you don't need the second ground of detention because you've got a basis for detaining on reasonable suspicion alone is not enough, because it may not be permissible to detain somebody on reasonable suspicion alone if the offence is trivial. But it may be you could nonetheless justify detaining them because you need to prevent them from fleeing, for example. Or it may be you can justify detention because, despite the fact that reasonable suspicion alone won't do it, there is an immediate necessity to prevent them committing an offence. Right. So they do all fulfil separate purposes. And the Court of Appeal in our submission was wrong in concluding that actually all one ever needs is 5.1, is the first ground, reasonable suspicion. That's not correct. I was going to come on to Hassan, but I'm happy to leave that then till after the lunch adjournment.
We take that too. I mean, we are familiar with Hassan. What's the relevance in this case?
So, well, the point I was going to take the court to in Hassan was that, in fact, they cite Jessius, they cite Al-Jeddah, they cite all the authorities that confine, in times of peace, Article 5.1c to criminal proceedings. They draw a distinction between what happens in times of peace under the Convention and its application and what happens in times of war.
I see. So you would say it's hammering home the same sort of themes.
Hammering home the same point, and it takes a position through Article 31 and the need for the Convention to be applied consistently with other international or law obligations of which it forms a part. And it doesn't displace the Convention, it modifies it. And so actually in our submission, Hassan does not have any bearing on this case as justifying a departure in times of peace. Quite the contrary, it makes it clear that one cannot depart in times of peace. And can I just give your lordships the references?
It's 551, yes.
Yes.
It's 551.
Right, well, we might...
Is that the most recent relevant Grand Chamber? The most recent Grand Chamber decision, is Hassan the most recent?
On...
Which was being relied on?
Well, Blockin is more recent.
Oh,
Blockin is more recent.
Okay, thank you.
Right.
Would you like the paragraph references? Or?
Yes, why not?
So they cite Jessius at paragraph 97, page 2595.
Yep.
And
well, we'll perhaps look at
last
that.
bit of paragraph 104 also makes it clear there can be no internment in times of peace.
97 and 104.
Yep. Shall we look at that over the adjournment then? Thank you.
My Lord Reed mentioned the case of Ericsson. We've had the case copied and I have copies for mine.
Thank you. This will be handed up. Right, 2:00 then.